DA's Brief with your District Attorney, Kayla Beauvais.
Hi, I'm Kayla Beauvais and I'm your Pueblo County District Attorney. In the last video, I discussed bond settings and bond hearings. Today, I want to walk you through some of the other court dates that you might see as a criminal case moves through the system. Understanding these steps helps explain how a case progresses from the time charges are filed until the case reaches a resolution. Let's start with a setting. A setting is a routine check-in with the court. At this appearance, the prosecutor and the defense attorney give the judge a brief update on what is happening in the case. This might include ongoing investigation, the defense gathering mitigation, reviewing discovery, or continued discussions about a possible plea. After the update, the court schedules the next date in the case. Next is a pretrial conference, or a PTC. In our jurisdiction, pretrial conferences are used in misdemeanor cases. It's a point on the docket where the prosecution and defense can meet, discuss the case, and where a plea offer can be conveyed or reviewed. In felony cases, a pretrial conference is usually not scheduled, and any communication typically happens outside of court. Another important hearing is the preliminary hearing. This hearing is held only in certain qualifying felony cases. At a preliminary hearing, the prosecution presents evidence to show that there is probable cause that the crimes charged were committed. If the court finds probable cause, the case moves forward. If the court does not, the charges may be reduced or dismissed at that hearing. You may also encounter motion hearings. These occur when the defense files motions seeking to suppress evidence, such as physical evidence, statements, or evidence collected during a search. These motions challenge whether law enforcement obtained the evidence legally. When this happens, our prosecutors subpoena witnesses and present evidence to show that law enforcement acted lawfully and that the evidence should remain admissible. If the court agrees, the motions are denied. If not, the evidence may be suppressed and cannot be used at trial. Another key court date is the pretrial readiness conference. This usually happens a couple of weeks before a scheduled jury trial. At this hearing, both the prosecution and the defense counsel announce whether they are ready to proceed to trial. For my office, being ready means our witnesses are subpoenaed and the evidence is needed for trial is prepared. If we are not ready, we may request a continuance, or in certain situations, we may dismiss the case if we cannot meet our burden of proving it beyond a reasonable doubt. I will cover plea agreements and jury trials in separate videos. Please continue watching our DA's Brief series for more information. Thank you.